Well, let me welcome everyone to this, this very special event. And I'm going to be very brief because you have a lot in store for you this afternoon and a lot of things that at least a few people have to say. But first, let me thank those individuals whose generosity made this possible. The Groot Professorship was, you know, sometimes professorships are funded by one or two people, but the Groot Professorship, many people appropriately contributed to this, this wonderful legacy, really, to a W&L legend. I also want to welcome the Law Council here. This is their fall meeting, and I met with several of you this morning, and I know you all have had a busy day, so we're very happy that this could coincide with that Law Council meeting as well. And of course, a special welcome to the front row Groot family. Ellen, of course, Roger's wife, Michael, Donna, and Stephanie as well. We have a couple of W&L alumni in there, so we welcome you back as alumni as well as members of the family. This is an event. This is a classic Washington Lee event because it causes us to honor our past even as we look to the future. Roger Groot was a Washington Lee legend. There's no question about it. Original, his originality, his creativity, his personal and professional integrity, his, what many alumni will recognize by the euphemistic term, academic rigor. He was someone who clearly had a presence and clearly had an impact on this institution. You know, there are people who, in their time here at Washington Lee, are shaped by Washington Lee and shaped by the values of Washington Lee. And then there's a small number of people who shape Washington Lee and who shape the values of this institution. And Roger Groot certainly falls into that category. He elevated the values of Washington Lee and personified the values in ways that few people do. The establishment of this professorship causes us to look to the future in this way. It ensures that those values will live on. It's, the tangible support helps the law school. It helps us in a number of ways here financially at the university, but the establishment of this particular professorship enables us to tell a story, and to tell a story that clarifies the values of this institution and preserves them for the future. So those of you who help support this have ensured that those values will live on in a number of very, very important ways. Sean will be introduced in a minute or two by Dean Demleitner, but I do want to take this opportunity to congratulate Sean, who has nothing in common with Roger Groot, except those qualities and those values that I mentioned before: originality, creativity, personal and professional integrity, and academic rigor. Other than that, they have nothing in common, but that's what matters, of course. It is my privilege now to introduce the grandchildren who have a special set of remarks for us.
I am not a grandchild. But since we are in a group of lawyers, whether you say the Lord's Prayer with debtors or trespassers, we've got a mixed crew here, so if you would just like to join them in the Lord's Prayer, I'll lead you. Ready?
Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. For thine
Thank you very much. And now I'll turn it over to our Dean for the introduction of the Roger Groot Professorship.
Good afternoon and welcome. I am truly honored and delighted to be able to introduce to you the inaugural holder of the Roger D. Groot Professorship. As you all know, I have not had the good fortune and privilege of knowing Roger Groot. But I feel like I'm being offered a second chance in life. The opportunity to get to know him through the testimony, through the stories of all of you, and of so many people outside this room who I have met, many of whom have given to the professorship, and who have told me about Roger. And also, I have the opportunity to learn about him through Sean, who is our first Groot professor, and who is very close to him, and who I know proudly and admirably will continue Roger's legacy at the law school. As many have told me, Roger was very fond of Sean, and I suspect that's in part because of all the values that the president told you about, that the two of them, I think, truly incorporate. Sean is highly respected in our community. One may even use the word beloved, as a teacher and as a colleague. She's won teaching awards from many of our student organizations, Phi Delta Phi, the Student Bar Association, the Women's Law Students Association. She was twice named the John W. Elrod Fellow in Teaching Excellence. But much more than that, she has been truly an outstanding mentor, not only for our students and our alumni, but she's also been a mentor for many young academics in the legal community outside this school. In the last 9 months since I've been named Dean of this law school, many people at other schools have come up to me and have asked me whether I've gotten to know Sean. Now, I had, because she was the chair of the Dean's Search Committee, but by all means, please don't blame her if you don't like the result. But so these people have come up to me and have asked me about Sean. Now, often she's chaired the search committee in the years that they were being considered, or she was on it. But more amazingly, she stayed in touch with them. She has mentored them as teachers. She's read drafts of their articles, and they've all so appreciated it. She visited at Washington University, at American and Brooklyn, and has long-standing relationships with faculty at these schools, because they all know that they can call her for advice, whether it is about teaching or about scholarship. And in fact, she has done the same for so many in this community, where she has read and commented probably on more papers and drafts than anybody else in this building, because we know that she is such a thoughtful and insightful commentator. Beyond this building, she has been a true friend to many in this community, and she has so generously opened the door to her home many a times. I think there's another indication of her deep commitment to others, and especially those less fortunate than we are. And that is the fact that she's one of the core faculty members of the Schaeffer program for the interdisciplinary study of poverty and human capability. Now, just some biographic data you should have as well. Professor Shaughnessy joined this faculty in 1983 after having practiced with the international law firm of Cleary Gottlieb in New York. She holds a Bachelor of Arts degree from the State University of New York at Binghamton and a JD with honors from the University of Chicago, where she was an associate editor of the Law Review and a member of the Order of the Coit. Professor Shaughnessy teaches civil procedure to our first-year students, usually in a small legal writing section, where she really has the most ability and input in mentoring young lawyers. She also teaches the difficult subjects of federal jurisdiction and jurisprudence, and has written in those areas as well as on child welfare law. Her engagement in the legal profession is obvious by the fact that she's one of the founding members of the Association of American Law Schools section on children and the law. I should mention how much she's done for building this institution. She served as Associate Dean of Academic Affairs, and some of you have heard me describe that position not only as the most difficult, but also the most thankless in all of legal education. And she's chaired every single major committee at this law school, including, as I mentioned, the last Dean Search Committee. She served as a sounding board, and I may venture to say, as a voice of reason to many in this law school and in the university community. Now this afternoon, Professor Shaughnessy has chosen a topic for her lecture that could not be more fitting for herself as well as for Roger Groot. The topic is Two Hunters, Reflections on Mentoring and the Formation of Professional Identity. Professor Shaughnessy.
Thank you all. Thank you, Ken. Thank you, Nora, for the fine introduction, more than I deserved. And thank you, children, for setting the tone for this afternoon. Greetings to all of you, colleagues, students, alumni, friends, and particularly to the Groot family. Ellen, Michael, Stephanie, Donna, sons-in-law, grandchildren, welcome. Nora's told you the title of my lecture, so I won't repeat it. But I will invite you at the end of the lecture to offer your own reflections, questions, or comments. Hunting is a craft, one of humankind's most ancient pursuits. It requires the acquisition of a great deal of specialized knowledge of the terrain, of the prey, of how to work with available weapons, and a host of other things I'm not competent to describe. Through the millennia, experienced hunters have initiated their juniors into the craft of hunting through the practice of mentoring. How mentoring is practiced today is my topic. The first hunter of my title is, of course, Roger D. Groot himself. I think anyone who knew Roger at all knew how much he loved hunting. Roger lived a rich, full life, and part of what led to that full life is that he had a passion, not just for his vocation, but for his avocation. Reflecting on Roger in this audience also led me to my topic. Most of you know, as I do through firsthand experience, that Roger was a superb mentor. I am convinced, as I believe he was, that good lawyers require good mentors. I knew my audience would include many colleagues and alumni who are working hard to be the best mentors they can be. I knew it would also include students who may be trying to discover how to be mentored. I hope to explore those issues with you this afternoon. I should mention at the outset that my account of mentoring is very much in the spirit of Sullivan et al., Educating Lawyers, popularly known as the Carnegie Report, as those of you who know the report will recognize. I also learned a great deal about mentoring from Johnson and Ridley's The Elements of Mentoring. I settled on my topic earlier this year, and I got to work in earnest this summer. But I'm awfully distractible, so I read a lot of other things this summer. One of those things is our local monthly magazine, published by Roger's good friend, Doug Harwood. One of the regular features of the Rockbridge Advocate is called Ruth Huffman Visits, in which contributor Ruth Huffman records a lengthy interview with a local notable, often a person with deep roots in the community. So this month's magazine, published late August, involved Ruth's visit with a hunter, my second hunter, Hank Beverly. He's an experienced bear hunter and a well-known breeder and trainer of hunting dogs. Now, I have never met Mr. Beverly, but I can imagine that Roger might have enjoyed knowing him and spending time in his company. But what Mr. Beverly had to say in his interview resonated with me as I was preparing this lecture. Indulge me while I read this, because as you can hear, I am no Virginian. I am certainly not from Rockbridge County, but I'll try and read Mr. Beverly's words as they were written in the Advocate. People's always asking me, how do you get them dogs to listen to you like that? Man, I live with them. I work with these dogs daily. You got to spend time with them, and the best dogs is the one that you raise from puppies. He learns you, and you learn him, and he bonds to you, see? Young kids is like that, too. If you take time to teach them, they'll love you for it. I try and teach some of these young boys how to bear hunt, and do it good. Some of them's learning right, the ones that love it. My granddaughter, she's 16. She's been wanting to go bear hunting. So I said I promised this year I'd take her and we'd tree a bear. I promised to let her shoot it. She likes dogs. Ain't everybody likes dogs. I like to see the young'uns learn the way. You teach them, they'll respect you for it all their life. My nephew Sean Lotz, I trained him up since he was a little boy, and he's a real good hunter. We go out hunting all the time together, and I've enjoyed watching him grow up to be a bear hunter. Makes you feel good, you know, to see these boys come up and learn the mountain lifestyle. You teach them to only kill what you can use and what you're allowed to take. You're only allowed to kill one. You kill every bear you see now, that's not being a sportsman. That's not right. And I won't to kill no bear that somebody else's dogs has run. I only kill something my dogs has run. It proves to me that I'm hunting right, and that's what I tell these young'uns coming up. Mr. Beverly's story can tell us a great deal about mentoring. Mentoring is a time-honored tradition. Elders impart their craft to the young people entrusted to them. The best mentors are themselves master craftsmen who through long hours and long years have honed their craft. The best mentors also transmit the values of their craft to their protégés. You teach them only to kill what you can use. I want to kill no bear that somebody else's dogs has run. A good mentor is also attentive to his protégés, as Mr. Beverly was when he focused on his granddaughter's attraction to dogs. How does this story about a hunter and his young'uns help us think about the challenges and possibility of mentoring in the legal profession? Does the process of becoming a hunter tell us anything useful about the process of becoming a lawyer? Well, first, I think the essential qualities of good mentoring haven't changed. I think they're the same regardless of setting. Mr. Beverly's story tells us something about those qualities, and Roger's life and career will help us identify those qualities too. So that'll be the first topic, the essential qualities of good mentors. But there are obvious differences between the formation of hunters and the formation of lawyers, which pose special challenges for law teachers and for established lawyers. The craft of lawyering also differs in important respects from the craft of hunting. The scale of the two enterprises also differs greatly in ways that impact the possibility of good mentoring in law. In the latter part of my talk, I'll address these differences. I've already touched on some of the qualities of good mentors. Good mentors are role models. They know what they're doing. They're worth watching. They teach by example, in the words of Barry Sullivan, our former dean, and Ellen Podgar. They have the knowledge and the technical skill to do what it takes to get the job done. I think we more senior people find it easy to underestimate how hungry law students and new lawyers are for knowledge of how law is actually practiced. They watch us and they absorb what they see, whether we like it or not. Good mentors know they're being watched and do their best to model excellence. Anyone who saw Roger in a classroom or a courtroom knows what I mean. He was always meticulously prepared and brilliant on his feet. You need only read Beverly Davis's description of the 17-hour days he and Roger spent in their hotel war room during a capital trial to see an example of Roger in action. By the way, that description and many other observations about Roger that I'll refer to are found in the tribute to Roger in volume 64, number 1 of our law review. Well worth reading in every word. It takes more than technical excellence, though, to make a mentor worth observing and emulating. A good mentor is a role model in an even more important sense. A good mentor acts in accordance with the values of his profession. Roger had that quality too, as our friend and colleague Frank Bowman remarked, and I'm quoting him. Perhaps the most striking thing about Roger was his consciousness that he was teaching not merely a subject, but a method of intellectual discipline, a way of being both a lawyer and a moral human being, a way of living a life in the law. Good mentoring also requires that a mentor be able to interpret his actions and his profession for his protege. In other words, good mentors are guides. They explain what they're doing and why. They share stories of their communities and their institutions. They transmit our different institutional and professional cultures. This task of thoughtful explanation and reflection is particularly important for legal mentors. Law is a complex discipline, and it's often difficult for young observers to understand the considerations guiding a senior's choice and action. Of course, it takes a fair amount of self-knowledge to understand and convey the reasons for our professional choices. The task of explanation also requires a keen understanding of the institution in which mentor and protege are situated. Roger, as Ken already mentioned, had that understanding. He had thought long and hard about legal education and about Washington and Lee's history and culture. He had a clear vision of W&L Law's mission, and he was vocal and unstinting, as any of his junior colleagues can attest, in expressing that vision. I venture to say his former deans can speak a little bit to how vocal and unstinting he could be on this topic. Roger also had a clear vision of legal practice and of what a good lawyer should be and do. He was equally vocal in explaining law practice, both his own and others. But mentoring is not simply a matter of performance, of demonstrating and explaining. A mentor is not just a role model and interpreter. A mentor is a coach. Good mentoring requires close, personal relationships between mentors and their proteges. Mentors observe their proteges and look for ways to develop their talents, to set them on the road to fulfilling their own dreams. Roger excelled at this. When he chose his clinical students, he looked for qualities he could encourage and build upon. He looked beyond and beneath the numbers, the GPAs, and the LSATs. He was looking for street smarts, for feistiness, for an ability to represent the clinic's clients with empathy and integrity. He also had the patience, the insight, the wisdom to look closely at his students and to see them true. Sometimes he saw them better than they saw themselves. Over and over, alumni report that Mr. Groot saw something in me that no one else saw. Amy Dillard, who graduated from here after spending time under Roger's tutelage in the Alderson Clinic, described her experience with Roger this way. Amy had her eyes on a criminal practice, as Roger knew. As she recalls, Mr. Groot always told us that the only place we could do any real good was the prosecutor's office. But quietly, he told me I didn't have the stomach to prosecute, and he was right. Perhaps above all else, this was the quality that made Roger a superb mentor. Mentoring wasn't about him. It was about each individual student and young lawyer. Roger had another quality that we can't overlook when we think about the coaching aspect of mentoring. Shall we say that, with Roger, there was no such thing as the tyranny of low expectations. Here is Lyman Johnson's description of being Grooted. Mind you, this is secondhand. I'm sure there are some of you in the audience who could give even more vivid descriptions of the process. Here's Lyman. Roger loved to liken the first semester of law school to boot camp. Students, tried by fire, came to appreciate that Professor Groot had such high hopes and expectations for them that anything less than their very best was unacceptable. If drawing that out required that, as with young Marines, he be relentlessly demanding, or if it necessitated cajoling, chastising, and seemingly never being satisfied, then that's how he would be. And he was, as legend rightly has it. His students flourished under his teaching. They are his educational legacy. Mary Napkin did experience Grooting firsthand, and she has this to say about looking across the podium, past Roger's shotgun shell coffee cup, and hearing her name being called. We each felt as if he had us literally in his sights when he called on us in class. And he kept the focus on us until we came to the realization, the point he wanted us to get. He really was great at letting students feel that they had discovered the issue, not that he told them, which is the sign of a great mentor. But it wasn't just students who came in for Roger's tough love. His junior colleagues were Grooted in their own way. Roger was infinitely warm and welcoming to junior colleagues, but make no mistake, he pushed us to grow and develop, to be the best law teachers and scholars we could be. That pushing made for some rough moments for some of us, but it also made for genuine growth. Roger was a true mentor to us, as he was to his students. He saw what we could be, and he pushed as hard as he could to help us see what he saw and do what it took to get there. Here I need to take a slight detour before I turn to the challenges of mentoring fledgling lawyers in the 21st century. I want to spend a few minutes talking directly about the ethical claims I have made concerning mentoring. In this brief time, I can't possibly do full justice to this question, which has occupied some of the best minds in our profession for their entire careers. Nevertheless, I don't think I can completely ignore the question either. So it seems to me there are three types of claims that might be made about the moral value of mentoring. Here it might help to think again about Mr. Beverly. I think it's possible to separate the question of whether bear hunting as a practice is itself a moral act. Some of you might think not, some of you might think so. From the question of whether the way Mr. Beverly treats his young'uns is a moral act, which is again separate from the question of whether Mr. Beverly follows the moral principles that govern hunting as he understands them, only taking what you can use, not taking a bear other hunters have engaged first, and so forth. This same sort of distinction can be made in thinking about the moral dimensions of mentoring lawyers. First of all, mentoring is a relationship that's characterized by caring, as Nell Notting has observed. So good mentoring is in some sense, almost by definition, a moral act. This is true whether the craft into which the protege is mentored is law, bear hunting, or something else. There are other dimensions to consider though. Communities of practitioners, be they lawyers or bear hunters, develop a common understanding of the ethic that guides their practice, and they judge each other on their conformity to that ethic. Mr. Beverly's comments are an example of that phenomenon, and the legal profession does this too, both informally and formally. We have institutions that hold our members responsible for breaches of our ethical codes. But my account of mentoring in law raises a further question. It's the is it okay to bear hunt sort of question. That question is whether the practice of law, as it is conveyed by legal mentors, is a practice with values worthy of emulation. One of my own law teachers, Tony Croneman, made such a claim in his article, Living in the Law. In that work, Croneman argues that the practice of law tends to develop the virtue of practical wisdom and the accompanying traits of sympathy and detachment. The Carnegie Report draws on this argument of Croneman's. More recently, Brad Wendell, who began his teaching career here, gave a similar account of the moral dimensions he finds embedded within legal reasoning. Brad argues that the rule of law itself has a moral dimension, and that therefore, when lawyers excel at the task of using legally constrained reasoning to analyze and solve client problems, they are doing work of positive moral significance. Tom Schaeffer, who was with us on the faculty during my early years here, spent much of his career wrestling with the question of how law could be practiced morally. As I read Tom, and indeed Tony Croneman in his later work, it became harder over time for them to justify the claim that the practice of law is in itself a morally valuable undertaking. On being a professional elder, Tom worried that our profession's claims to moral value might be delusional. He cautioned that we need to cast a critical eye on the morals of our profession and the ethical dimensions of our work. From this more critical stance to Tom, the values internal to the profession are not sufficient to establish the moral worth of practice. Instead, the moral worth of any particular legal action, or indeed legal career, depended upon external moral values. For Tom, the source of these values, the position from which criticism might come, was the community, particularly the faith community. I'm afraid I'll have to leave this point without having come close to doing it justice. But I will note, at least, that part of the reflective task for mentors and for proteges lies in raising and puzzling through these ethical and moral issues that permeate our professional lives. I risk leading you to think that a person has to be a saint to be a mentor. Not the case, as I'm sure Roger would be the first to admit. Roger was not a saint, and I don't imagine that Hank Beverly is a saint either. People can have plenty of flaws and still serve as good mentors. But there are some flaws that really do interfere with good mentoring. When a relationship between a junior and a senior is all about the senior, bad mentoring results. This can happen when the senior is too busy or self-absorbed to really attend to the junior. It can happen when the senior tries to satisfy his or her own personal needs through the mentoring relationship, needs for ego stroking or indeed for romance, by way of example. It can also happen when the senior is threatened by the junior and tries to make the junior dependent. So some caution is warranted in mentoring and in choosing a mentor. but I hope I have convinced all of you that a good mentor is a treasure to be sought and once found to be prized. I'm going to turn to the second issue I wanted to take up briefly. That is the challenges for mentoring lawyers. My account of mentoring poses challenges for mentoring in law school, as the authors of the Carnegie Report observe. The emphasis on the importance of learning professional roles by observation and modeling poses a quandary for many law faculty. As Tony Croneman wrote, every law teacher belongs to the community of university scholars, but the objective in teaching law is not to prepare students for membership in the same community. The aim is to equip them for a different kind of life. In teaching law, one must accept this fact and help prepare students for a life lived in the world of affairs. This means that we as faculty face particular challenges to bridge the gap. It is incumbent upon all of us in the academy to do our utmost to understand what lives in the law are possible today and to convey to our students the promise and challenge of practice to the best of our ability. In spite of the gap, there's a great deal that even faculty members long removed from practice can do to mentor students. There is much about law practice we can model, many skills and values we can exemplify, and much encouragement and critical engagement that we can offer. Barry Sullivan and Ellen Podgar, building on the work of the Professionalism Committee of the ABA section on legal education, have explored how law faculty can better serve as mentors for students preparing for the world of affairs. They suggest a number of ways that faculty, being responsive to student concerns and receptive to sharing time with students, can model a relationship much like the attorney-client relationship. We are fortunate at W&L because the prerequisites for good mentoring are in place. We have a tradition of putting a premium on working with students to draw upon. Our curriculum, from the first year small sections to our third year practica, is designed to provide every student with many opportunities to work closely with faculty. But those conditions don't ensure that our students will find mentors in our ranks. Students need to actively seek out mentors, and faculty need to keep a lookout for students who are in particular need of guidance. We at W&L have another invaluable asset to offer students seeking mentors. Many in our ranks, like Roger, are both teachers and active practitioners. Our clinicians and our extended faculty of practitioners directly model excellence in law practice and deliberately build in time for the individual critique and reflection that is essential to real professional growth. As everyone in this audience knows, I think, we built our third-year curriculum based upon the principle that all of our students need substantial experience doing legal work, actual and simulated, under the close supervision of experienced practitioners. As Lyman Johnson, David Millen, and Bob Danforth note in their recent book chapter on our curricular reform effort, the third-year program idea began even before the publication of the Carnegie Report, but that report influenced the final shape of the reform. We hope to create conditions under which mentoring relationships would develop and grow. My account of mentoring also poses challenges for mentoring in law practice. Tom Schaeffer noticed this danger when he observed on being a professional elder, I sometimes think that the practice of a profession in modern America is impossible, because modern America is, to use Alistair McIntyre's image, a society of strangers. There's a very real question, I think, whether genuine mentoring is possible in many law practice settings. Mentoring in the fullest sense involves a close working relationship that endures long enough for the fledgling lawyer to find his or her own wings, requires an investment of time and attention that might seem like a luxury to many senior lawyers in current practice environment. Both junior and senior lawyers are more mobile than they once were. Many lawyers practice in very large, impersonal organizations. Under those conditions, it can be difficult for young lawyers to find mentors willing and able to invest in them. It may also be difficult for mentors themselves to avoid feeling alienated from their own organization. If they lack a commitment to their institution's culture and a belief in its value, their protégés are likely to be similarly alienated. I don't have any easy answers to these challenges. Many of you in this room who are leaders in your firms and active in professional organizations can speak to this question better than I can. I do not believe that large organizations are fatal to the development of mentoring relationships. To the contrary, healthy large organizations are built of overlapping clusters of real community in which protégés can be encouraged to grow and thrive. No doubt it takes work to build and maintain such an organization. Communities are fragile, and once broken, they are difficult to rebuild. Similarly, I believe that even large organizations can keep and attract committed participants who will work to keep the organization's culture healthy and its values intact. There are real challenges confronting practicing lawyers who seek to mentor or be mentored. These same challenges, though, make good mentoring even more important for the young lawyers who are seeking to make their way in an ever more demanding profession. Those who find the time and strength of character to mentor deserve gratitude. They mentor as a service, but also, I suspect, they, like Roger, find mentoring meaningful and rewarding. Lastly, I promised to talk about being mentored. Mentoring, as I have said, is a relationship. Like any healthy relationship, a mentoring relationship involves give and take. Students and young lawyers should actively seek out prospective mentors. Once a mentor has been found, a protégé needs to take initiative and engage with the mentor. Watch closely, listen attentively, but don't stop there. Ask questions. Seek to understand the whys of the mentor's actions and decisions. Bring your own professional questions and dilemmas to your mentor for advice and guidance. You're not obligated to follow all your mentor's advice, but you are obligated to consider it seriously. Protégés also need to grow up. A mentor's goal is to help a protégé learn to practice independently. A good protégé gradually lessens her dependence on a mentor and ultimately leaves the nest. The relationship shouldn't end, though. Mentors deserve to hear from you about your professional progress. Your success is, to an extent, theirs as well. Part of the purpose of mentoring, also, we should remember, is to build and maintain the institutions which have supported the mentor and her protégés. As a consequence, protégés also owe a certain duty of loyalty, I think, to the institution and the profession in which they have been mentored. I think most of you know how this lecture about law and hunting and Roger has to end. It's time to piss on the fire and call home the dogs. I'm more honored that I can say to be the holder of the Roger Groot Chair. Thank you all, and a particular thanks to all of you who recognized Roger through your support for this chair.